Hello and welcome again to the Commercial Tenants Association webinars. Today is the last in our series of the property life cycle. I'm Stephen Pippard, I'm the Managing Director of the Commercial Tenants Association. And in this webinar, we'll be covering dilapidations in commercial property. Joining me today are Paul Rayburn of Dilap Solutions and Martin McKeague of Walker Morris. Gents, do you want to just give us a brief introduction to yourselves? Starting with yourself, Paul.
Thank you very much, Stephen. Hi, I'm Paul Rayburn. Amongst my niche property consultancies is Dilap Solutions, in which my colleagues and I advise tenants of commercial and leisure properties on dilapidations matters to minimise dilapidation settlements at break and at lease expiry on properties around the UK. Thank you.
Thanks, Paul. Martin?
Thanks. Yes, my name is Martin McKeague. I'm a partner at Walker Morris Solicitors in Leeds. I have acted for over 20 years for both landlords and tenants in relation to dilapidations claims, both on an interim basis and a terminal basis.
Thanks, Martin. So in this webinar today, dilapidations claims can be substantial. So tenants really should fully understand both their obligations and take steps prior to and from the commencement of any lease. Paul, really just let us know what is dilapidations, in terms of what does it cover and what is a tenant should be expected to understand.
Okay, Stephen. Well, to give a broad perspective, a lease is, of course, a contractual arrangement between the landlord and the tenant. So contracts contain obligations and responsibilities, and it is common that a lease will place upon a tenant responsibility for some, or more usually all, of the repair and decoration of the property, but also if there are any alterations that you've carried out to the property during the currency of the lease, to reinstate those alterations, in other words, remove them and make good any damage at the end of the lease. And I think the extent of that is often, as we'll cover in this webinar today, the extent of that is often underestimated. The costs which can be involved are often underestimated as well. When it comes to lease expiry, what normally, or break, what normally happens is at or about that time, it's usually 2 or 3 months in advance, the landlord will send out a chartered building surveyor to go around your property, armed with the lease and any licenses to alter that there may have been, to assess what, in their opinion, are your breaches of those obligations to repair, decorate and reinstate alterations, and price their remedies. This then ultimately manifests itself in what's called a schedule of dilapidations, or quantified demand, as another name for it we'll cover later on, which is served upon you, so some official scary type service by the landlord solicitor, and it will normally be an Excel type document, so itemizing every item and with a total at the end. So that's how in summary how it comes about and how it's presented to the tenant.
Thanks for that, Paul. Please just do use the Q&A function if there are any questions that are pertinent to raise to the panel today. We'll be monitoring that and answering any of those questions to both Martin and Paul. So we've sort of understood what are dilapidations, but I think the first and foremost is to understand that commencement of contract and understanding mitigation measures is what to look for or be aware of, Martin, in that contract.
Yeah, I mean, I think dilapidations are interesting because I think tenants often focus on the rent. That's sort of the central focus, making sure the rent's as low as possible. But people can then tend to forget that dilapidations and the ultimate liability for dilapidations can be many multiples of the annual rent, and that sometimes does get lost. I think the biggest mistake that I see, and I'm sure Paul will second this, is that I think tenants fail to appreciate when taking a new lease that unless the lease is drafted in a particular way, then if the building is dilapidated, i.e. already in disrepair, already in a poor condition, the standard repairing obligation that a tenant will take on in a lease means that they will assume responsibility for that historic disrepair. And with that in mind, therefore, then it's absolutely critical at the outset that the tenant goes into it with their eyes open and appreciates that it's going to be no defence at the end of that lease to say, well, no, hang on a minute, Mr. Landlord, when I took that property, it was already dilapidated. Because the contractual basis for dilapidations claim is in the lease, as you'd expect. The tenant will have a covenant to generally keep the property in good or substantial repairing condition. There are variations on that general repairing obligation, but that's sort of bog standard repairing obligation. And the critical point to realise is that an obligation to keep the property in repair means essentially to put it in repair, because the only way you can keep it in repair is to put it in repair. So if on day one the roof is leaking, it's no defence for the tenant to say, well, actually, that roof was already leaking when I took the lease, because, as I've said, an obligation to keep the roof in repair will mean the tenant, in order to comply with that, has first of all got to put it into repair. So we'll come on to talk a little bit about ways you can sort of ameliorate that sort of risk and deal with that through schedule of condition and limitations of those. But I think from a practical perspective, the dilapidations liability arises from the lease, and therefore then it's absolutely critical important that that lease is drafted in such a way to give the tenant protection at the outset from that sort of claim for historic disrepair that didn't happen on their watch.
So again, this goes back, I guess, to the whole series that we've been talking about, from lease renewal, from lease commencement, is understanding what your lease is about. And there's different types of leases, aren't there? Whether it's a fully insuring and repairing lease, or it's something different, because that will have an impact on dilapidations.
It will. I mean, I suppose at a very high level sense, there are two types of leases in a delapsed context. There's a full repairing and insuring lease, which is typically where the tenant takes a lease of the whole building, and then there'll be an internal demise only. I suppose even with an internal demise only, the tenant is indirectly generally liable to contribute towards the cost of repairing the structure as well. So dilapidations resonates not only where it's a full repairing and insuring lease, i.e. where the tenant takes the demise of the whole building, but also where it has an internal demise only, and there is a corresponding service charge obligation as well.
So I guess the first thing is understanding your lease and getting that professional advice from both a surveyor and a solicitor at commencement or renewal of leases. But then it's then starting to look at mitigation of, not just relying on the rent rate service charges entering into an agreement, but understanding your exit costs and how to mitigate them. And you did mention, Martin, the initial building survey or condition survey. Paul, do you want to just sort of talk us through what is required or what is best to any new tenant organising that lease, whether it be a renewal, an extension, or a new lease, what they should be getting undertaken to mitigate these, quite substantial costs that could be attributed at the end of the agreement?
I will, Stephen. At this point, I'll introduce a concept that I'll need to continue, which is distinguishing between two distinct disciplines, two different types of chartered surveyor that are relevant in this process. So first of all, there is the building surveyor, the chartered building surveyor, and their specialism and training is in identifying disrepair, so problems with a property, breaches of those covenants to repair, decorate and reinstate alterations, and to price what it would cost to remedy them, to put them right. So they have that construction experience and knowledge. Then there is the valuation surveyor, who we've talked about before, which is in fact my discipline. The valuation surveyor values properties, and we'll come to this later on in terms of a defence against dilapidations claims, which is that the impact of the disrepair on the property's value can often be far less than the cost of putting those things right. So we'll come back to that later. So to answer your question in this context now, Stephen, at the start of a lease or at lease renewal, in terms of properly gauging what exposure you have as a tenant to this time bomb, as it can often be, of dilapidations, it is a chartered building surveyor, which we employ both in Dilap Solutions. So one of my colleagues, as a building surveyor, would go and carry out a dilapidations assessment of that building. In other words, advising what are the issues that need remedying and putting right. Now, at the start of a lease, let's ignore a lease renewal for now. So in taking on a property from the outset, a common attempt at damage limitation these days is to have a schedule of condition attached to the property. And the way that would work in theory is that the repairing clause that Martin was describing earlier on, to keep the property in repair, which, as Martin was very perspicaciously emphasising, includes to put it into repair if it's already in a bad state. No defence to say, but it was in a shocking state when I took it, Mr. Landlord. The schedule of condition is photographic and often with text, precisely, or as precise as possible, recording the condition of that property in anticipation of your lease starting. And the repairs clause will say that you're obliged to keep it in repair, but in no better state than is evidenced by the schedule of condition attached. So in theory, that will protect you. We'll go on perhaps later on to explain potential pitfalls in that and how to best protect yourself against them. But it will be apparent from the concept of what I've described that that is at least benchmarking at the start of your lease the condition of the property, so that you are not expected to or contractually obliged to hand it back in any better state than that. So in principle, there is some comfort in terms of that.
And I guess as well, schedules of condition can help in rent reviews, etc., because you're reverting back to the condition that the property was held in, and the rent should be reviewed on the basis, rather than any improvements that a tenant has made to the property that the landlord can then make use of in a rent review.
Correct, Steve. Yes, absolutely.
We should probably mention as well, shouldn't we, that although the sort of default tenant's repairing obligation is to keep the property in good and substantial repairing condition, the sorts of scenario that Paul's there describing of, heavily dilapidated building, maybe short-term occupation, just going to use it for storage purposes. I think a well-advised tenant, therefore, they might look for some sort of repairing obligation on a pretty limited basis, say to keep wind and water tight, or in a clean and is a broom swept condition. So there are sort of degrees and grades of repairing obligations, and if you do have a particularly dilapidated property, short-term occupation, then you might be well, it would be sensible then to look for something fairly limited in terms of the extent of your repairing obligation.
Absolutely right, Martin. And in fact, that will provide a far better defence than arguing over the detail of a schedule of condition.
Yeah.
It's limited to wind and water type, for example. So in all negotiations, your starting point has to be your ultimate that you're aiming for, and then you perhaps compromise to something a bit less. But I wouldn't suggest starting. But certainly if it's a building that is in a poor state already and you only want it for a fairly simple or basic use, I wouldn't be starting with a schedule of condition, no, because I'll briefly run through them now. There are pitfalls with schedules of condition. So first of all, buildings, of course, all properties inexorably deteriorate. So if your schedule of condition at the outset has, for example, as a commonly used example, notes that a timber windowsill is about 25% rotted. When your lease expires in, say, 5 years' time, and that rot has advanced to now being 50% rotted, you can't fix just your extra quarter of the sill that has rotted away. Really, the whole sill needs replacing. So even though you've got this apparent protection to repair and hand back in no better condition than at the outset, you've got no choice but to hand it back in better condition, because otherwise you're handing it back in worse condition, in breach of your contract. So it's a superficial protection often, a schedule of condition. Other elements that go wrong with them is we often assume that it covers decorations as well, but unless it's specifically referred to in the decorations clause, the obligation to redecorate, then it is not. So it needs to be codified and spelled out in the lease in that way. Then, to take it further to where they can go wrong, you might have in the schedule of conditions something very significant like the flat roof over the back of your shop is in poor condition but currently serviceable, something like that, and you have to hand it back in no better condition. 2 or 3 years into your lease, water starts pouring in, and you phone up the landlord and say, my roof's leaking, to which the landlord says, right, not my problem, because there is no corresponding obligation in the lease upon the landlord to repair that thing that you're apparently not responsible for handing back in any better state. So in order to stop that water coming in and damaging your stock or contents, it's you that ends up fixing it anyway. So a schedule of condition is far from a panacea. It is one of the measures that can be taken, but with other bits to be coloured in, like I say, with caution, positive landlord obligations, carrying it through to the decorating provisions, those kind of things. So it is a starting point to start to limit your exposure to a blank checkbook in terms of dilapidations at lease break or expiry.
Yeah, and I guess it's an insurance policy and a mitigation element to sort of stop that. As we can and have seen between us, that a delapsed claim can be many multiples of the monthly rent or even annual rent, dependent on size.
It can be a catastrophic sum, yeah, absolutely. Yeah. I mean, to qualify in that regard and to slightly remove the fear that we're putting into this, it is not unusual for dilapidations claims to be exaggerated somewhat at first instance. There is a thing called the dilapidations protocol that we might come back to later on. It's kind of like an instruction manual for how dilapidations negotiations are meant to be conducted. It's part of the civil procedure rules in England and Wales. It's designed, I suppose, to try to keep these matters out of court, but that is the ultimate sanction for them. Again, to quell fear, very few do end up in court, less than 1%. But that dilapidations protocol does, in theory, require that claims and negotiations in response to those claims are honest by the professionals involved. Perhaps they're not necessarily always that honest from the outset, I would suggest. So terrifying though an initial dilapidations claim can be, bear in mind that it's probably exaggerated to a greater or lesser extent, and that's before you bring in your professionals to defend your position.
Thanks, Paul. As I said, we've got a Q&A function at the bottom. If you want to raise any questions to myself or the team here, please use that functionality. So sort of going forward on that, I guess it's looking at some of the words that come around dilapidations claim, and often there is that what is a yield up clause and how does that affect a delapse liability? Martin, is that something that you can answer?
Yeah, I mean, I suppose the starting point for that is that there's two types of dilapidations claim. There's one which is referred to as an interim claim. So that's a claim that will be brought during the term of the lease, and that might manifest itself, for example, in a number of different ways. The landlord might say that the roof is in disrepair. He might give what's called a Jervis and Harris notice to the tenant, which most leases will contain a clause entitling the landlord to give the tenant notice to repair. If the tenant then doesn't carry out the works within the prescribed time frame, the landlord can then enter the premises, carry out the work, and recover the cost of the work as a debt from the tenant, which then sidesteps the Section 18 defences, which I'm sure Paul will talk about a little bit later on. So that's an interim claim. Now, a yielding up provision, as you would imagine, deals with the position at lease expiry. So where the tenant is required to yield up the premises, and generally speaking, the tenant will be required to yield up the premises in accordance with the tenant covenants in the lease. So in compliance with the repairing obligation, in compliance with the obligation to decorate, in compliance with the reinstatement obligations, and the compliance requirements in relation to statutes and regulations as well. So yielding up, in a very general sense, is talking about the requirements and obligations and responsibilities of the tenant under the lease that it is required to satisfy as at the expiration of the particular lease.
Anything to add on to that, Paul?
No, that seems a fair summation to me of what yield up involves, Stephen.
Cool. So a question that has come in and sort of takes us on to that next stage really is does a landlord have to serve a schedule of delapse at the end of the tenancy? And does the tenant need to have that from the landlord?
Well, there's no obligation on the landlord to bring a claim at all. I mean, that's entirely in the landlord's decision and gift as to whether it brings a claim. It'd be pretty surprising if the landlord didn't bring a claim, assuming that there are some dilapidations. I think the other point probably to make people aware of is that assuming a lease is by deed, which typically any lease for more than 3 years will be, then the landlord essentially has 12 years to bring its claim. Now, that's not to say that any landlord particularly would wait for 12 years. Why would it? Most claims and schedules of dilapidations are served within the last 12 months of the lease or within the first 6 months or 12 months after the lease has expired. I guess if the question is directed at the landlord bringing a claim but not serving a schedule of dilapidations and simply saying, oh, well, this building's in a poor state of preparing condition, isn't it? You've got to pay me 100,000. I think as a tenant, under the protocol to which Paul had referred, dilapidations protocol, you would want to be saying to your landlord, well, that's all very interesting, but first and foremost, you need to serve me with a formal schedule of dilapidations, setting out what the breaches are, what the remedial work is you say needs to be done, and what the cost of works is. And then next stage then, as Paul also mentioned earlier, is you would then be well advised to go and instruct a building surveyor to tell you whether or not what the landlord is saying is accurate or not. It's very difficult, and I don't think a tenant would be well advised to try and settle that dilapidations itself. I think you really should be deferring to a qualified building surveyor in those circumstances.
So that really follows on is what is the procedure that needs to be followed to serve a schedule of dilapidations? Paul, do you want to just talk us through, because there is quite a sort of a protocol that needs, as we talked about, that needs to be followed?
There is, and I think in fairness, Stephen, in terms of the detail that's relevant for these purposes, we've probably already covered it. It is the landlord normally using a building surveyor. That's the most appropriate professional to prepare that schedule of dilapidations. So identifying in that clearly articulated way, which is usually an Excel document, as I say, referring to which lease clause has been breached, what the breach is, describing it, slipped roof slates, failed decorations to whatever, rotted door frame, identifying what the breach is, whereabouts on the property it is, what the proposed remedy is to put that right, and the cost for it, literally itemizing every single item. And at the end of that schedule, those figures for repairing, redecorating and reinstatement items, those breaches, are aggregated. And to that, the building surveyor then adds fees for the project, the supposed project management of that to a concluded scheme of works. And that forms part of what the protocol calls a quantified demand. And for these purposes, we can assume that's more or less one and the same thing as the schedule of dilapidations, except that quantified demand may well include other elements in addition to those costs of works. It may well also include what is generically referred to as consequential losses, which would be, for example, loss of rent. So it is not unusual. I'm not saying it's valid. In fact, it's very rarely valid, and we can come back to this later. But nonetheless, in perhaps something of an opportunistic way, a landlord will take the view in for a penny, in for a pound. So my building surveyor has told me that to do all of these works will take 3 months. So I'm going to claim 3 months loss of rent in addition. In practice, more often than not, a property will sit empty for at least the period it would take to do those works anyway, because of market forces, or because the landlord wants to do other works to the property to alter it or upgrade it in some way that's nothing to do with dilapidations, but they're going to be causing a void by their own desires, their own works they wish to do. and that period could comfortably include remedying the dilapidations as well. So, in other words, the loss of rent claim is more often than not opportunistic, and once challenged in one of those ways I've just suggested, is removed. So that's the schedule of dilapidations and how it's served upon the tenant effectively. And then, assuming the tenant instructs their own building surveyor, negotiations would move on from there. This, of course, is all on a cost of purported works basis, which perhaps neatly segues to where the tenant's principal defence probably lies, certainly in England and Wales, which is the statutory defence of diminution in value, which I'm guessing we'll come on to quite soon, Stephen.
Yeah, so I guess, you know, we've now been served with a schedule of dilapidations. So there's now an onus on the tenant to do something about it. Mm-hmm. And actually there's a time frame that they should be responding within. I think it's 56 days. Do you want to just talk about what then, after being served with the schedule, a tenant should be looking to do?
So this protocol, and Martin can perhaps talk about the more serious aspects of it. So like I say, it's an instruction manual or guidebook, if you like. There are no express obligations to follow it, but there are potential penalties if a matter ends up in court and the party has not followed it. So it's advisable to do so. And in terms of that responding to the landlord's claim, that 56-day period, which you correctly referred to there, Stephen, the tenant must provide what is called their response to that claim. So that the reason that it's an Excel document that passes between opposing building surveyors is the tenant's building surveyor will then add on more columns at the end, and they'll put, if they disagree, and they'll note whether they agree or disagree with the proposed fix, the proposed remedy for each item of breach that's been noted. So they might say, for example, this is not a breach, it's noted in the schedule of condition attached to the lease. I don't think it's deteriorated at all. And they'll put in a zero cost for that. Or they may say, your claimed remedy for fixing the flat roof of £10,000, you can actually fix it in this way with this more economic system, perfectly adequate, £1,500. So that it tells a story as you look across this schedule. And that will pass back and forwards with these 56-day time slots for each side to do their bit between building surveyors.
And Martin, is there anything to add on in the legal perspective of that?
Well, the delapse protocol is there in the same way that there are lots of protocols around these days dealing with all sorts of claims, of professional negligence protocol, medical negligence, debt protocol, all sorts of protocols. So dilapidations has its own protocol. And I suppose the underlying rationale of any protocol is to promote the exchange of information between parties and to regard litigation as being a last resort. And if you disregard the protocol from a tenant's perspective and from a landlord's perspective, and you just issue proceedings before you've gone through the protocol, you run the risk that the tenant might say to the court, well, look, we want this litigation stayed until the landlord has complied, until it's provided me with its valuation report or an account for the works undertaken or its quantified demand. I mean, tenants, being blunt, are always on the back foot dilapidations claims, because unlike a lot of litigation, the tenant will be liable, just a question of how much. Whereas in most litigation, you might have arguments about liability before you move on to quantum, but the nature of dilapidations is, as Paul said earlier, all buildings deteriorate, and therefore then there is always going to be a dilapidations liability. The difficulty is actually ascertaining what that liability is, particularly if, for example, you don't know what the landlord's intentions are, you don't know what works they're going to carry out. You might have vacated the building by the time you get the schedule through. So the protocol is all about encouraging parties to exchange information, and I suppose sometimes it works and people do adhere to it, other times people don't. And like most litigation, then, you know, people try and manipulate things to their advantage, and I guess that's just human nature, really. So but if you don't comply with it, on either side, then you can be penalised in relation to costs. I must say my experience is by the time you get to trial, what happened or didn't happen pre-action is generally forgotten about, frankly. But it can resonate at the beginning of the litigation if one party has not played ball or has been sort of precipitous in terms of the action they've taken.
So you talked through the dilapidations protocol, and is there a body that governs dilapidations procedures?
I suppose that I think the protocol, I think, probably issued by RICS, I'd imagine. I mean, in terms of a body, I suppose the ultimate arbiter of any dilapidations claim or dispute is going to be, generally speaking, the court, or in limited circumstances, you might make a reference to an arbitrator or to an expert. I mean, I suppose the way in which building surveyors act will be moderated by RICS. I don't know, Paul, are you valuers? Is that the same or not? I'm not sure.
I think in theory you're right, Martin.
But in practice,
I think that there's rarely ever any sanction in practice. It's back to what you said, Martin, about the raison d'etre of any such protocol. They are there to encourage open and frank negotiations with a view to finding a negotiated settlement. And I think to that extent, the protocol, I mean, it became part of the civil procedure rules, was it 2012, I think, Martin? So it's about 10 years old now.
Yeah, I was going to say, about 10 years.
And I think it works well, in fairness, because to varying degrees, most parties involved and experienced in dilapidations tend to more or less accord with it. People get punctilious and querulous about minor defaults, but at the end of the day, you're moving together in the same direction towards a negotiated settlement. And it's where you end up at, if you're in dispute, that often becomes a game of brinksmanship and posturing, as it is in any set of negotiations. And I guess we'll come to that shortly.
Yeah, and I guess one of the questions, another question coming is why is dilapidation so complicated and costly? And I guess that refers back to the complication of the building and the amount of kit that's within it, I guess.
And so that Martin and I can earn a living, I think.
This is the main reason, Paul, isn't it? I think.
Yeah.
But I was going to say, in terms of why is it so complex, I guess, because there's so many different moving parts. Why is it so expensive? Well, I'm not sure whether that question is asking why is it so expensive to resolve, or why is it so expensive to conduct the claim? I mean, I guess if the question is directed at sort of, why does it cost so much to resolve these claims? I suppose the short answer is because if this becomes a full-blown dispute, you need a building surveyor, you need a valuer, you're probably going to need an M&E expert as well, aren't you? And then you're going to need a solicitor. So you potentially, each party, you've got 4 sets of professional advisors.
But it is a classic oxymoron again, isn't it? It's a classic oxymoron again, I think, Martin, in that I know we would say this, wouldn't we? But more often than not, by trying to save money, by trying to cut any of these people out, you will more likely than not waste more than you save in terms of what you end up paying out in the settlement sum. So yeah, it's an expensive game, and that's why we're giving advice to think about it from the very start, to minimize your exposure and risk and protect yourself. So I think a fair rule of thumb that Martin would probably agree with is it ends up being the most expensive and the most terrifying when the first time you give it any thought is when you get the schedule of dilapidations from the landlord. Yes, it will then be terrifying and probably very expensive in both ways, the sums you pay out and fees to resolve. If you planned ahead and in particular thought about it from the outset when taking on the lease, damage limitation or mitigation will pay off, will reap dividends for sure.
The other point really, and I don't think I can emphasise this enough, is that because the tenant will be liable, there's no question that there is liability on maybe a very different extent of liability to what the landlord says, but the tenant will be liable for something or other. And then what you've got to realise as a tenant is that this process is being conducted at your expense, because almost certainly,
wrong.
Yeah, almost certainly in the leases,
more or less, but you are,
yeah, that there'll be a provision that says basically the tenant pays the professional fees in relation to any breach of covenant, scheduled dilapidations, etc., etc. So unless and until you've actually protected your position by making a well-pitched settlement offer to give yourself cost protection, this whole sort of machinery, which is moving towards, a settlement and a resolution, it is being conducted at your expense. And I think that's
the cost clause in the lease for breach. There's usually a general clause about any breach of covenant under this lease. The tenant will pay the landlord's costs. Sometimes it will say reasonable, sometimes it won't. Sometimes it will have the word indemnity, which basically means the landlord can charge what he likes. But his costs in terms of surveyor's fees, lawyer's fees, blah, 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 in pursuing and resolving that breach, so that's what dilapidations are, breaches, those costs are paid by the tenant to the landlord. So you're not only paying your own fees, you're paying the landlords as well. So again, that's another reason to get good advice, sound advice, preferably when you're taking on a lease, certainly at the time of dilapidations, to move as swiftly as you can with the best defences to a negotiated settlement. So to box in the landlord as quickly as you can to reappraise their expectations of what they're going to get out of the dilapidation settlement. So if they have been, because often dilapidations are, one of the reasons they can become so heated is because the landlord's expectations haven't actually been realistically managed by their advisors. So coming back to this thing that I think we should perhaps get on to explain quite soon is the diminution in value thing. So a landlord may have said to a landlord's building surveyor may have said to him, look, I'm going to make a claim at £250,000 for cost of works. The landlord then has that sum in his head, it's in the bank, without the tenant, without his building surveyor actually having said to him, but if your tenant advises this section 18, this diminution in value defence, it might be a lot less. So the landlord's been misled from the outset in pursuing it. So what you have to do as the tenant is get your ducks in a row to advance the best and most robust defence in order to, like I say, realign or reappraise the landlord's expectations.
So, we talked about sort of getting your condition survey, sort of getting the schedule of dilapidations, getting a surveyor to sort of argue the fact of the cost of those repairs and renewals, etc. And you've sort of mentioned diminution of value. And my question here was can the same or should the same approach be taken with all claims? And clearly, it brings us into what is a Section 18 notice and what is diminution in value.
Right. So in high level or broad terms to explain. So as we've already established, a dilapidations claim is initially or primarily calculated on this cost of works basis. What's wrong with the property? What's it going to cost to put it right? And that's negotiated between building surveyors, that distinct type of chartered surveyor on both sides. However, there's a piece of statute in England and Wales that applies in England and Wales, goes back to 1927, and is surprisingly underused, but nonetheless is exceptionally effective. And it's Section 18(1) of the Landlord and Tenant Act 1927, and it's very brief, and what it effectively states is that the damages that a landlord is entitled to for breaches of the covenant to repair, for dilapidations, will be the lowest of the reasonable cost of carrying out those works or the impact those breaches have on the property's value. And similar common law defences apply to the other covenants to redecorate and to reinstate. In my experience and that of my colleagues, through our different practices, so Rayburn Consulting, which was involved in these seminars earlier on, so in transacting properties, is that rarely, if ever, does the cost of remedying everything equate to the impact on the property's value. The impact on value is usually considerably less. And there are lots of reasons for that, but in summary, the principal reasons are are best explained by the valuer applying two filters to the building surveyor's schedule. The first filter is to remove items which are likely to be overridden or destroyed by landlord upgrade and improvement works. And it should be borne in mind that the landlord in this context is the hypothetical landlord. It's the assumed purchaser of the building at the date your lease expired, or the date you vacated the property, whichever is the later. So if the actual landlord is saying, well, I'm not going to do these things, I wouldn't do them, that carries little weight. The point is, what would, in the opinion of the valuation expert, the market transacting surveyor, so not the building surveyor, the valuation surveyor, what would most probably happen to that property? Those contemplations take precedence. So that might be, well, look, this property is out of date. As most properties are, they were originally leased 5, 10, 15 years ago. At the very least, they're going to need some modernisation of fittings, of equipment, of light fittings, the old style light fittings replaced with LEDs, for example, the avocado toilets and vanity units stripped out and replaced with more modern Italian style, whatever. So, or a shop that's of a size that has no market anymore, a former Argos, for example, might need dividing up into smaller units. Often you'll have vacant floors above a shop that nobody has any use for anymore. Nobody stores stock, so they'll be converted to residential. An industrial building where the offices, as they were leased to you, are dated. They haven't been touched since the 1980s. They really need gutting and modernising. So all these kind of things you can, offices similarly, old kit, old specification. So if the valuation surveyor is of the view that the hypothetical purchaser would do works to modernise and upgrade the property, as would make it most attractive in the open market, therefore it makes sense to do it. If those works are likely, as they will, are likely to override or destroy, or to use the technical term, supersede claimed items in the schedule, then they are snuffed out, they disappear. So the genuine breaches that the building surveyors have identified, they genuinely, in theory, need fixing at the prices that they've negotiated between them. But if reality is likely to snuff them out altogether, that's what takes precedence. So that's the first filter that the valuation surveyor applies. And the second filter is not all items of breach actually are material to impacting the value of the property. And the rule of thumb on that is the older the property is, the lower the expectations in the open market as to how it will be presented and what it will provide. It's expected that it will be a wind and watertight and fairly tidy thing, but precise presentation isn't necessarily expected. So your 50-year-old warehouse building of brick walls and corrugated asbestos roof, the expectations as to the standard of repair of that are obviously lower than they would be for its 5-year-old modern equivalent up the road. So the valuer is also applying that market experience to say, yes, that's a breach, but whether you fix it or not will make no difference to value. In other words, the law of diminishing returns applies. So what we will often do, say from an agency perspective, if we're putting a property on the market, there is nobody to pursue for dilapidations. A property investor, a landlord comes along and says, I bought this warehouse, for example, it's pretty tatty, I need to stick it on the market. I've had a building surveyor go round, there's his schedule, he tells me I need to spend £150,000 on it. How much will you rent it out for me for? And we'll say, well, we'll go through and we'll tick the principal things, wind and watertight, secure, safe, blah, blah. Say, if you spend £50,000, I'll get you £5 a foot. How much will you get from me if I spend the full £150,000? I'll still get you the same. The law of diminishing returns. So those principles that apply in the real world in the open market are what Section 18 as a defence is all about in dilapidations. And overlaying the valuation surveyor, the valuer, overlaying what the building surveyor has done with those principles to come to inevitably a far lower figure as the true likely level of damages that the landlord is entitled to.
Thanks for that, Paul. And I guess the other scenario is the intended use the landlord tends to do at the end of your lease, because if it's going to be redeveloped, demolished, etc., then there's an impact that there's no dilapidations due. Is that correct, Martin?
Yeah, I mean, I must say it's pretty unusual for the landlord to be demolishing. It obviously happens, but it is pretty unusual. I mean, I would say that I mean, you know, Paul knows far more, can talk far more eloquently than I can about sort of valuation principles. What I would say from a litigation perspective is that ultimately, if the landlord's done the works, then typically speaking, as a tenant, you've got some difficulty, you've got greater difficulties there, because the general principle is the cost of the works is the best evidence of the loss. It's not to say that you don't have defence you can run, but it is a more difficult position to be in. Where the landlord hasn't done the works, then there is, in my experience, far greater scope then for the tenant to take issue with the common law claim, as it's known, so basically the cost of works claim, and seek to limit its liability by virtue of those arguments. But yeah, to come back to your point, Stephen, I mean, ultimately, if the landlord's going to knock the building down, then it's going to wipe out the dilapse claim, isn't it, entirely? Equally, you know, if it's going to carry out a wholesale refurbishment, redesign, reconfiguration, such that you know, nothing will be left, and again, you know, as a tenant, you can have a pretty good defence of that claim there, aren't you? The difficulty often is actually getting to the bottom of what the landlord is actually going to do in order to allow you to make a well-pitched offer, because the landlord will obviously try and keep it as broad as possible.
And I guess for that type of defence, it's looking at local planning regulations. You know, if there's been any planning applications for change of use or to
you have to be a bit of a foolish landlord to create a paper trail like that. So a couple of things I would add to what Martin was saying there in reverse order. Firstly, on that point, without going into the detail of Section 18, the landlord's intentions, the actual landlord's actual intentions, are one part of it. And as Martin has rightly said, and I suppose as I've coloured in there, it's unlikely that a landlord will expose their true intentions if they're going to undermine their dilapidations claim. Dilapidations claims are commonly looked as an opportunity to secure a bit of a windfall pot of cash beyond what might be spent on the property. So the approach that the valuation surveyor should be taking in using Section 18 defence, this diminution in value defence, is I don't really care. Like I said earlier, I don't really care what your actual intentions may or not be, Mr. Landlord. My point is the hypothetical purchaser, the likely purchaser of this building at that precise snapshot in time, not now, a year after the lease has expired and the world's changed in the pandemic environment, but back when the lease expired, that snapshot in time, which is what matters at law in terms of the assessment of the date for assessing the damages. My opinion is the purchaser would have been of this ilk and would have done this with the property, and therefore they would have snuffed out a whole load of what you're claiming by supersession works. One other point, I agree with Martin to an extent that obviously if a landlord has so-called done the works, that makes it far more difficult for a tenant to defend. However, it is rare, not impossible, but it's rare in my experience that the works actually done turn out to be precisely as claimed. So there will often be a lump sum put together which apparently covers these, but they struggle to break it down. And in fact, there's been quite a bit of improvement and upgrading and betterment works going on. So it requires forensic examination by both the building surveyor and the valuation surveyor to say that's fine. I'm sure you've spent £147,000. Well, let's look very precisely at what you've done and let's go back to the building and look around it. And more often than not, that forensic examination exposes more overriding, supersession thing I was talking about, and more fixing of things that probably actually have no impact on lettability or value at all. They're just nice to have. So the defence can still be run.
And then I guess one final point is we've just come out of COP26 and we see lots of things coming about with green leases now. And there's actually a format of green dilapidations. And this is often trying to negate the fact of taking out embodied carbon in terms of, you know, a tenant has carried out improvements to a building. They are leaving it in often a much better condition that they've received it in. And the landlord surveyor is often saying, for me to let this, it needs to be taken back to Cat A standard. So it's taking out probably a good standard of fit out with, you know, up-to-date equipment, facilities, to literally strip it out and put in something that may not be fit for purpose in the market, dependent on the new incoming tenant. So I guess that's another defence, and you know, it's more a behavioural change we need to sort of predict within the marketplace going forward as ESG becomes more prominent, both in terms of an institutional landlord and a tenant's ESG requirements. And are you seeing any of that in the marketplace now, Paul or Martin?
I would, well, funnily enough, we were only talking about this the other day, weren't we? And I think we just finished our call, and a case I'm dealing with for tenant on some offices that they fitted out 5 years ago. They were built, what will they be, 15, 20 years old, these offices, on a business park, a science park. And my client took a 5-year lease 5 years ago, did a very expensive and pretty high-end fit out of the space. I would say fairly universally adaptable fit out, not that bespoke to them. And yet the marketing agents, who needless to say are also the building surveyors dealing with the dilapidations for the landlord, have said that they are unable to let it in its fitted out state, and they're going to go ahead and gut it, put it back to full open plan, category spec. And of course, it will still sit empty. Half the park's empty right now. So I mean, that's and I've tried to shame them with the greening information and the sustainability argument, but they seem to be unreceptive to that at present. I think this is going to be an evolutionary thing, Stephen, in fairness, and you know, ultimately, probably led by economics, and then overlaid with some greenwashing, as in what. And I'm hoping that the landlord in my case, and I'm talking about, if not his advisors, the landlord might think, hold on a minute, maybe my advisors are just after project fees here, because they're not going to get an agency fee anyway. It's going to sit empty for ages, so they might as well have their project fees. Maybe their advice is driven more by what they want out of it, rather than what's best for me as client. And for me to spend all this money to still have a building that won't be occupied, and perhaps over time is less likely to be occupied than left with its very nice fit out in place, that those basic economics might start to take precedence in how landlords instruct their advisors rather than being led by their advisors.
Thanks for that, Paul. And then really just to leave us, we're sort of just over on time. Is there one thing that sort of to leave from this seminar that you would sort of give advice to, and one takeaway for a tenant really to be thinking about when the dilapidations claims or a schedule of dilapidations sort of hits them on the doorstep? Paul?
Do you know, I think I'll pass it to Martin. I've done more than my share of talking in this, if you don't mind, because I strongly suspect we'd both say the same thing anyway on this.
I mean, I would say, repeat what I said earlier. This is obviously a talk to tenants, isn't it? And get some proper advice, and make a well-pitched, realistic settlement offer as early as you can to give yourself cost protection. Otherwise, you will be litigating at your own expense. And I think that's, you know, having done this for what, 20 years or so, then if I'm running a delapse claim for a tenant, that is always going to be the advice.
So, thanks, gents, for your time today. This webinar will be available for download on our events page. And our next seminar will be based on sustainability and will be scheduled for December this year. So all it leaves me to say is thank you for joining, and thank you, gents, for your time and support on this series of Life Cycle.
Thank you to Stephen
Thanks,
and Martin.
Stephen. Thanks for inviting
in the background. Thank you.
Cheers. Thanks, everyone.